5 seconds to go. Start. Then the Law Commission took note of the insertion of Section 198B under the Amendment Act 26th of 1955 and recorded in paragraph 15.138 of the report, the rationale behind Section 198B as follows, para. Section 198B, which was introduced by the Amendment Act of 1955, deals with prosecution for the offence of defamation where such offence is committed against certain high dignitaries and public servants in respect of their conduct in the discharge of public functions. The section lays down a special procedure for such cases. The Court of Session is empowered to take cognizance of such offence, without the accused being committed to it for trial, upon a complaint in writing made by the public prosecutor. It is not necessary for the aggrieved person to sign the complaint under this section, but the complaint has to be made with the previous sanction of a specified authority. There are also distinctive features which will be discussed below. Para. According to the 41st report of the Law Commission, Section 198B was inserted to provide a special procedure for prosecution for the offence of defamation where such offence is committed against certain high dignitaries and public servants in respect of their conduct in the discharge of public functions. The specialties of the procedure were, that the offence was made cognizable, that the complaint could be by the public prosecutor and need not even be signed by the aggrieved person, and that the precondition for taking cognizance is that it was sanctioned by a specified authority. Para. It is interesting to see that the 41st report of the Law Commission fails to note how Section 198B inserted by the Amendment Act of 1955 was worded and how it was changed in 1964. The Amendment Act of 1955 made Section 198B applicable to offences other than defamation by spoken words. This exception was removed only by the Amendment of 1964. The 41st report of the Law Commission makes no mention of the 1964 amendment. Para. Without reference to the amendment of 1964, the 41st report of the Law Commission records in paragraphs 15.139 to 15.142, a different version of history starting with the battle that preceded the 1955 amendment. It appears therefrom that there was a huge opposition to the offence of defamation being made cognizable. The opposition came from the Indian Federation of Working Journalists. The Press Commission reported that the consequences of making the offence of defamation cognizable, are very dangerous, as it may enable the police to arrest without a warrant, to take preventive action contemplated under Chapter 8 of the Code of 1898, presently Chapter 11 of the Code of 1973, and to conduct searches. Para. After expressing the above apprehensions, the Press Commission recommended that a procedure may be devised so as to strike a balance between those two considerations.